You're driving home at night when the red and blue lights fill your rearview mirror. You weren't speeding, you weren't swerving, but now an officer is walking up to your window. The truth is, that moment is one of the most vulnerable you'll ever face. Because it's not just about a broken taillight, or speeding, or swerving. They're about what you say, what you do, and how easily police can use it against you. I'm attorney Matt Wayman, and today I'm here to talk about 5 deceptive tactics Missouri police are trained to use during traffic stops, and what the law actually says about each one. Tactic 1, small talk that isn't small. It starts friendly. Where are you headed? What are you up to? It may sound like harmless chit-chat, but in Missouri, that's the first step of an investigation. The moment officers start asking questions unrelated to the traffic violation, you're being evaluated. In State v. Stover, the Missouri Supreme Court said that traffic stops are considered non-custodial encounters, meaning that officers can ask you questions without reading you your Miranda rights. You may just think that you're being polite, but the officer is building reasonable suspicion. Here's the takeaway. You don't have to answer questions that go beyond your license, registration, and proof of insurance. You can say, "Officer, I prefer not to answer any questions." That's calm, lawful, and protected. Tactic 2, the safety excuse for a pat-down. Sometimes officers claim that they need to frisk you for their own safety. That sounds reasonable, right? But Missouri law says otherwise. In State v. Haldeman, the Missouri Court of Appeals threw out evidence when an officer conducted a pat-down without any real reason to believe that the person was armed or dangerous. The trooper admitted that the driver was not aggressive, made no sudden moves, and gave no cause for alarm. The court ruled that general officer safety concerns don't justify a frisk. There must be specific, articulable facts suggesting danger. Contrast that with State v. Goff, where the Missouri Supreme Court upheld a pat-down. It was late at night. There was evasive behavior surrounding vending machines, and outstanding warrants were found. The difference? In Goff, there were concrete facts justifying the officer's concern. So remember, Missouri law doesn't let officers pat you down just because they feel uneasy. They need a clear, factual reason. Calm behavior, open hands, and steady communication protect you more than argument ever will. Tactic 3, the false authority move. This one's subtle, but serious. An officer says, "I have probable cause to search your vehicle." Or, "You can't say no." That's when many people give up and agree to a search that they don't have to allow. In State v. Earl, the Missouri Court of Appeals made it crystal clear that when officers falsely claim they had the legal authority to search, that's coercion. The officer in Earl told the driver that he had probable cause when he didn't, and the driver's so-called consent was later thrown out. The court quoted the U.S. Supreme Court's decision in Bumper v. North Carolina. When an officer announces that he has authority, the situation is instinct with coercion. And when there's coercion, there's no consent. So if a cop claims that they can search your car no matter what, know this: they can't. That's not confidence. That's a bluff. And Missouri courts have ruled that a bluff invalidates consent. Your best move: stay calm and say, "I don't consent to any searches." Don't argue. Don't explain. Just hold that line. Tactic 4, extending the stop without cause. Maybe you've handed over your license, answered their questions, and now you're just sitting there. Minutes turn into half an hour. Maybe they're waiting on a canine unit. That's illegal. In State v. Thomas, decided in 2024, the Missouri Supreme Court reaffirmed that once the purpose of the traffic stop is complete, officers cannot detain you longer without new reasonable suspicion of another crime. The court followed Rodriguez versus the United States, emphasizing that extending a stop for a drug dog or extra questioning without independent cause violates the Fourth Amendment. So if the officer's already given you a warning or a ticket, the clock's done. You can ask, "Am I free to leave?" And if they say no, they need a legal reason. Otherwise, everything that happens next could be suppressed in court. Remember, polite persistence works better than confrontation. You're not challenging authority. You're asserting your rights. Tactic 5, using your silence against you. This one's almost unbelievable, but it's true. If you stay silent without clearly saying why you're staying silent, police can twist it into guilt. In Missouri, the courts have followed the U.S. Supreme Court's rulings in cases like Salinas versus Texas, holding that silence isn't automatically protected unless you invoke your right. That means that if you just go silent during questioning, a prosecutor may later argue that silence implies guilt. That's your constitutional shield, but it only works if you raise it. Let's put this all together. Missouri law gives police some room to deceive you, but not to coerce you. They can ask tough questions. They can use friendly tones, but they can't lie about their authority, pat you down without a reason, or hold you longer than the law allows. If an officer says, "I'm just going to take a quick look," remember Earl, consent under false authority is no consent at all. If they say, "I'm going to pat you down for safety," remember Haldeman, safety alone isn't enough. If they start running a drug dog around your car after the ticket's been written, remember Thomas, that's unlawful detention. And if they treat silence as guilt, remember this. It only counts if you clearly didn't claim your right. Every case, Earl, Haldeman, Golf, Stover, and Thomas, built a line in Missouri law about what police can do and what they can't. Knowing that line may save your freedom the next time the red and blue lights are flashing behind you. Look, the goal isn't to fight police on the roadside. It's to stay safe, calm, and to protect your rights. So if something goes wrong, your attorney can fight it in court later, where it matters. I'm attorney Matt Wayman, and if you found this video helpful, please check out my next video, What to Do When Cops Come to Your Door, the knock and talk. Because the same tactics that start on the road can show up to your front door.